recorded. And the recording will be available on our YouTube channels. So please subscribe to our channel and stay tuned for the updates. Please be free to post your questions in the chat and they will be addressed in the questions and answers segment at the end of the session. Now I would like to introduce our esteemed speaker, Ms. Diel Duke, attorney at law. Ms. Diel Duke is a dedicated attorney at law called to the legal bar of Trinidad and Tobago for almost a decade. She operates a law practice in Chaguanas, Trinidad, where she specializes in helping individuals and businesses secure their assets through comprehensive, tailored legal advice and representation. She also offers guidance in estate planning, ensuring assets are protected and distributed according to clients' wishes. Committed to legal empowerment, Ms. Diel provides personalized, hands-on guidance to her clients, navigating the complexities of wills, trusts, and probate matters. Whether drafting legally sound wills, advising on succession strategies, or assisting with estate administration, she delivers clear, effective solutions tailored to each client's needs. Beyond her legal practice, Ms. Diel actively educates the community through seminars like these and legal aid initiatives, making crucial estate planning knowledge accessible to all. These seminars on will and succession planning helps to reinforce her commitment to equipping individuals with the tools to safeguard their future finances. Please join me in welcoming Ms. Diel Duke. Ms. Duke?
Good afternoon, Simonique, and good afternoon, everyone. Thank you so much for having me yet again to discuss this topic on wills and succession planning. Before we even start, just some housekeeping. I would have loved for today's session to be a lot more interactive. However, I'm told that you can post your responses, your questions, and your answers in the chat. So I will be asking some questions throughout the process, and I'm hoping that you all are able to interact and share your opinions and questions so that we could have a great discussion today on wills and succession planning. Now, as Simonique said, I have been an attorney at law for approximately, I've been an attorney at law for 9 years. So almost 10 years I've been in practice. And as a result of that, I've had firsthand experience on some issues that I feel as if, it can be addressed with greater knowledge by members. So I'm grateful that PSCU has taken the mantle yet again to engage its members and members of the public in educating themselves to be better able to position and plan for the future. Now, let me, 1 second. Right. So today's seminar, we'll be dealing with 3 aspects we'll be breaking it up into 3 different parts. So the first one, we will take into consideration, look at all the considerations that you do prior to estate planning. Then we will look at the formalities of making a will. I know that a lot of persons who are interested in doing it themselves, they would want to pay close attention to that. And most importantly, what happens after that? What do we do after our loved one dies? What to expect? So we're going to break it up into these three sessions. So one thing about wills and succession planning, you will find the area being one where persons somewhat delay, procrastinate, they take their time because nobody wants to deal with the issue or deal with the idea of death. So that is always a challenge. So we have a quote here from Napoleon Hill, which states, procrastination is a bad habit of putting off until the day after tomorrow what should have been done the day before yesterday. And with that, let me go into one of my stories at my office. So imagine receiving a frantic phone call late at night from a prospective client. And the client is saying, Miss Duke, we need your services now. A relative is in the hospital and is apparently on his deathbed. He is now desirous of putting things in place to distribute his assets before, God forbid, he passes. So I started asking the relevant questions because he's in the hospital, so I need to know the physical and mental position that he's in order to make any will or last document. So I started asking about the formalities of the will and whether the person had the mental capacity to make the will. When I received the information, the person was indeed 96 years old. And I asked the question, why did he wait until the age of 96? Which is a great age to reach. It means that he really lived a very, very long life. But he waited until 96 years old to determine or to decide that now is the time to execute a will. So I've asked myself the question because this has been a recurring event at my office for the last couple of years. I've had another circumstance where merely days after making the will, the person would have passed. And I keep asking myself, why are these persons waiting till the very end to make such an important decision? And I realize once again, it's because we do not have the knowledge and the information needed to make informed decisions prior to. So why do we delay when it comes to planning for future? And I'm not sure if anybody wants to interact, but I'll give a couple seconds for some responses as to why you have delayed in planning so far. And we'll look at the box. Fear of the unknown. Thank you, Shakaila. So fear of the unknown is absolutely one of the responses. Let me see some other responses. Okay. So I've gotten all those things before. I've heard persons indicate that I don't have time to make a will. I don't like thinking about that. It creeps me out because dealing with our own mortality or the mortality of our loved ones is always an issue that is a challenge for persons. I'm seeing some other responses in the chat. I'm trying to get it. Okay, that becomes real. That's true. Fear, procrastinating, it's just not something you think about. That's true. So, I mean, I've gotten all these responses before. Fear that children will put them out. That's a very real fear. So I've gotten all those things before. I've even heard before when people make wills, they die faster. And from my experience, that is not the case. The issue is that when we make the will, we are generally on our deathbed. So it's not that the will kills persons, but it's just that we wait until the very, very end to make a will or to even consider estate planning. So everything stated are very real possibilities. And this is why we look at the considerations before making a will so that we are able to make the best decision, because making a will is only one way for succession planning. Right? So the importance of succession planning. It ensures that the assets are distributed according to your wishes. Not anybody else, not the law, not the state, but according to your wishes. It protects loved ones. You are able to put things in place for minor children. You're able to put things in place for persons that need additional assistance. For instance, if they put things in place for pet arrangement. It minimizes conflict, which is huge because persons I have observed that persons have a misconception as to who is entitled to benefit and who is entitled to apply for a grant in an estate. So oftentimes somebody passes and we find uncle, auntie, cousin, everybody running to the forefront because they are not familiar with what their entitlement to the estate would be. So therefore it causes conflict, and we always want to try to avoid conflict. It reduces probate delays. Depending on the property that you have in hand, depending on the property that you want to distribute to your beneficiaries, it may not have to go in a will. It could be handed over. For instance, if you have jewelry and all these things. So that's something that is, the type of gift is important. And you are able, as I stated above, appoint trusted executors and guardians. So you have a choice as to as to who you appoint in particular spaces and not the law in particular. And we'll go into that a little later. So what is succession? Succession is the transmission of the rights and obligation of a deceased person to his legal heirs or next of kin. So a person's asset may be distributed in the following ways. I mentioned it briefly earlier, but we can do inter vivos gift, which is a physical transfer of the property while you are alive. So whether you decide you want to transfer the land while you're alive, there are ways to do it that could protect the person that is giving it, that gives them a say as to how it could be distributed, and there are the benefits there. But it goes, once again, after speaking to your legal representative, you would really and truly be able to determine what is the best way forward. You can do a will or testamentary disposition, meaning that the will take effect after death, so you transfer the property after your death, or through the operation of law. So in the event that you departed this life without leaving a will or disposing of all your assets, the law determines how your property should be distributed. And that means, of course, that you don't have a say as to who benefits and who doesn't. So according to the Succession Act, it gives the right to every person to distribute or dispose of their asset by will executed in accordance with the act of all property owned by him. So you have that right to distribute your property in accordance to your wishes. So we are talking now about inter vivos gift. Inter vivos gift are gifts given while you are alive. And in some cases, it may make more sense to give it while you're alive. It saves money because the person will not have to make an application for a grant of probate, which we'll learn later has to be done through an attorney at law. So automatically, even during your lifetime, the person will have access to the property and use it. So these are considerations that you take into account. If it is, in fact, you still want to maintain some control over the property, control and use of the property, particular arrangements can be made to join persons, to become joint owners with the person. So for instance, I have here joint accounts, if you have a joint account and one person dies on the account, the right of survivorship kicks in. So it means that the surviving person will be the sole owner of the property once the death certificate is produced. That is generally done in terms of conveyancing and land and so on. It safeguards the person. I think somebody stated earlier in the chat that they are fearful that the children, if you make the will or you do something like that, the children will put you out. However, there are ways in which if it is you do that, you maintain a right to possession of the property either through a life interest or through joint ownership, where it is you maintain a say as to whether this property could be sold. They need your signature, they need your permission before doing anything with the property. So once again, depending on the nature of it, you'll be able to better determine what is best for the occasion. I'm seeing some questions in the chat. That's why I pause a little bit reading. These will be addressed shortly. Okay. So wills. Wills are generally the most popular way of distributing assets. It means that you have all the right to use the asset during your lifetime, and because the will only takes effect upon your death. So, I mean, a lot of people prefer that because it's inexpensive, it's clear, you could state clearly exactly what it is you want and intend to happen with your estate, and most importantly, you maintain use of your property during your lifetime. So a will is a revocable declaration in prescribed form made in contemplation of death, expressing the intent of the person making it regarding the matters which he intends to take effect after death. When they state that a will is a revocable declaration, the misconception that people have is that once you make a will, that is the document. Generally stating yes. However, you have the right and the opportunity to make changes to that document right up until your death. So if your circumstances have changed, your property possession has changed, anything of the sort has changed, you have a right to change this document, and the last dated document will be the valid document at the end of it. Of course, based on this and providing that it would have been done in compliance with the Wills and Probate Act, because there are formalities that are required when making a will in order to validate its existence. I'm seeing some questions coming in, so give me a minute. Let me see some comments. Seeing if 5 persons name on a will, how can it be divided? It can be divided. It means that the 5 persons own the property together. Another question, how could you measure the value of an estate? Well, the value of all the assets. If you have a house, a car, all those stuff, based on that, you are able to calculate the value of the estate. Can a house be given to multiple persons in a will? Absolutely. You could have multiple beneficiaries to one property. In terms of the order in which persons die, if the persons pass away prior to the testator of the will, because remember, the will only takes effect. The question is, let me read the question. Can a house be given to multiple persons in a will? The answer is yes. The follow-up question is, and if it is, after all those persons pass away, who and how is the property transferred? Now, it depends on when these persons have passed away. There is if the persons would have passed away before the will came into effect, it means that the last survivor is the sole owner of the property because they would have passed away before the testator of the will, they would have passed away before that person died. So therefore, the testator had the opportunity to change it, but they wouldn't have changed it. So therefore, their share would have, if they passed away after the person would have died, then it means that their share goes to their estate. And of course, once again, it depends on the manner in which it was distributed. So if it was given as joint tenants, it means that the survivor may be the sole owner of the property. If it was given in equal shares or distributed, then it means that their portion would go to their estate and so on. But I always advise persons that in circumstances like that, that may be more complicated, it's important to seek your legal representative and get specific legal guidance on that kind of question. Right? I'm getting some more stuff as we move along. I would just go through. So, if you have a named beneficiary, do you still have to prepare a will? No, depending on whether you have insurance. If you have an insurance policy and you have a named beneficiary, or if you have shares in the credit union, up to a certain amount, I believe after death, the credit union is able to give $50,000. And if you have more remaining, then they would have to apply for a grant. But if you have a named beneficiary, the named beneficiary will benefit. What happens when an executor dies after the will is probated? We will come to that shortly in that segment. I would lay that out. Or before the will is probated, we'll come to that shortly. So it is still, you could still go ahead. Is it true that a will does not supersede a beneficiary of a particular account? No, a will does not supersede. It goes back to the intention of the parties. And of course, you have to show evidence. Generally, where there is a named beneficiary, the general rule is that it's the intention of the deceased person to benefit the beneficiary. So unless there's evidence that she probably sent write a note and said, okay, from that money that you're collecting from this account, I want you to give this person this, give this person that. It means that now she doesn't intend to solely benefit you, Darlene. Beneficiary, I'm not sure what you're referring to. I'm not sure if you're talking about an executor. Mel Jones, it's not that the will should not be stapled, but we need to keep the integrity of the document. If there's any tear or anything in the document, the attorney will, of course, account for the condition of the will. So I've never really heard of that will not being stapled, but I do keep my documents very secure and without folds and tears and so on. Sure. Who or what is a testator? So let's continue and then we'll take up some more questions after. So, I have some questions and some scenarios that I want to hear from you all from. But we'll have multiple components, and that's what I'm going on to. A testator. So somebody asked in the comments, what is a testator? A testator is the person making the will. So this is the person, I am making a will, I become the testator under the will, under the law, right? So that is what they refer to the person that is making the will. An executor is the person appointed by the testator to execute and to make the application for the will. The beneficiaries are the persons expected to receive a benefit under the will or document. So if you're giving it a car to John, John is the beneficiary of it, and most importantly, witnesses. So there are multiple parties to a will, And you will realize that these persons are absolutely essential and important when dealing with the formalities of a will, because each of these persons play an integral part of the validity of the will. Okay, so I'm going back. I have a scenario on the screen. Let me make sure I'm seeing it. So John is 16 years old and terminally ill. He wants to make a will to leave all his assets to his mother, Sandra. He recorded his will in a voicemail. Let me know, yes or no, whether he can make the will and whether the will is valid, based on your knowledge and understanding right now. Okay, so Josanne said no, not valid, no. Nope. Okay, so Sherwin said, yes, I believe he can, and it is valid. A lot of no, not valid. Not legally, but maybe ethically. Okay, well, Sharon, I could probably see how your reasoning. Wonderful. So Mel said it. He must be 18 years and over, and it must be in writing. So therefore, no, this will, he cannot make a will, and it will not be valid because it's not in writing. So thank you so much, Mel. So a video recording is not permitted. According to the law, the will must be in writing. There are circumstances that could possibly, it still needs to be in writing, but there are circumstances that shy away from the formality, because if, there is one that's called a deathbed will. So you don't know you're going to die, you end up in a situation, God forbid, a car accident, something, and you decide, oh my gosh, let me just say, I want this to go to A, B. Because of that circumstance, you made the will or you made the proclamation in anticipation of death. And in that circumstance, the court may deem it valid. Okay, I see another question here. If you had a registered will, can you make a new will without registering it? Yes, you can. So what happens in that instance is that persons have the option to keep a copy of the will in their documents. They have the option to keep one by the attorney, and they also have the option to lodge the will in the probate registry. So what happens is that after a person dies and prior to applying for a grant, you make an application for a search. You do a search in the probate registry. So most likely it will be easy to find, because once you have lodged it, it will be placed in the probate registry. Once you do the search, it will pop up. And in those circumstances, they will pop up. But if you have a will of later date, then that will be the one that is valid. So it will more or less invalidate the one that is lodged at the probate registry. But of course, there has to be the necessary pleadings that one was found. However, another one was found that is of a later date that invalidates whatever, and the courts will then make the decision. Can a property be given in a will even though the owner doesn't have a deed for the property but live all their lives? Well, even though they don't possess a deed, persons may have interest in a property, and it means beneficial interest. So even though there are some persons that live all their life, but they know they are not the owner of the property. In that instance, they cannot give something that they don't own. But if it is, you don't have a deed, but you build a house on it because somebody gave you a piece of land to buy, you build a house, then you have beneficial interest in the actual house, the chattel, not necessarily the land, and you can give that in a will. It has to be pleaded specifically, though, and the attorney will be able to do that. How to get an executor? Well, an executor is anybody that you trust, Mr. Clark, that you would want to an executor is anybody that you trust to execute the document. I always tell persons, ensure that the person that you select to be your executor has the resources necessary. because as we go on to the end, we will realize that any grants must be applied for through an attorney at law, and they are paid based on the act. So therefore, if you have a larger estate, then you probably pay a lot more. So ensure that the executor have the resources to make the application. I agree, Ms. Jackson. Right, so I will come back to some questions later on. Let us go to the other scenario. So Roy and Susan is getting married in June 20 on sorry, that's supposed to be on June 25th, 2025. He visited his attorney because he wants to safeguard his assets prior to the marriage. He made a will, leaving his assets to his mother and brother equally. Is this will valid? You all could type your answers. Let's see. No. I'm seeing no. Yes, it's valid. Yes, yes. Oh gosh, no, not valid. Why first? Well, I agree. Yes, yes. Marriage invalidates the will. Okay, so we're now seeing you must leave your spouse something. So I'm seeing that some of us are legally inclined, which is great, or have knowledge about the process. The long and short answer of it is that no, the general rule is that no, the will is not valid. Marriage invalidates the will. Once he gets married in June, it invalidates the will. However, somebody states that if he leaves $1 for her, what that shows is that you would have made the will in contemplation of marriage to this particular person, and you would have made certain arrangements. So once again, it's not always fair, it's not always right. So therefore, even though you make that decision, the court might decide, I'm throwing this out, this is it's not equitable or it's not fair, and so on. But the general rule is that marriage invalidates a will, unless, of course, you made it in contemplation of the marriage. And by specifically stating Susan in the will. But don't do that. It's not fair if you're building a life with somebody. Scenario 3, right? Let me just run right back just so I can clear up and not miss anybody. Wonderful. Can an executor be a beneficiary? Long and short, yes. Right? So scenario 3. And I'm doing this so that we could get an idea of what the considerations that we have to take or make before making a will or when dealing with or deciding on succession planning. Right? So scenario 3. Charles has gotten legal guidance on how to draft a will. He selected his executor and all the beneficiaries of his estate. He is now ready to execute the will. He called his son Barry and his wife Mary to sign as witnesses to his will. Mary signed first, then Barry signed at the top of the will. After being satisfied, Charles signed at the bottom of the document. Is this will valid? So let me hear you all. Mel? Shelly? No. Everybody saying no so far. Any yeses? Okay, Glenn said yes. He's seen somebody putting something in there. All 3 persons must be in the room at the same time to sign. Witnesses must both be present when the testator sign. No, no, no. Witnesses sign last. Thank you, Diane. Okay, so I've gotten so many responses, and I thank you because it shows that everybody is paying attention. Not sure family members can witness. Okay, so there are multiple aspects in this scenario, right? So the good thing is that Charles had received legal guidance on how to draft the will. So in essence, long and short, yes, you can draft your will yourself. However, if it is you make some grave mistake, then the will becomes invalid. So as quickly as you do it, is as quickly as it goes, right? So one, he selected his executor and all the beneficiaries, which is great. He did that correct. He's ready to execute. He called his wife Barry, his son Barry, and his wife to witness the will. Now, the question becomes whether Barry and Mary would have been beneficiaries of the will. The general rule is that beneficiaries cannot be a witness to a will. So therefore, it's not that it will invalidate the will, but it means that any gift given to Mary in the will or Barry in the will becomes null and void. So therefore, they would receive nothing under the will. Then Mary signed first and Barry signed at the top. So the law states, when we go into the formalities, which is coming next, that the will must be signed at the foot of the will, and it must be first signed by the testator, which is Charles in this document. It must first be signed by the testator in the presence of the will, the witnesses, who then sign in the presence of each other and the testator at the foot of the will. So therefore, based on how all the signatures all over the place, no, the document will not be valid. Yeah. So I hope we take that away. Beneficiaries cannot witness a will. If it is you're doing it for yourself, the beneficiaries cannot witness. You will invalidate whatever gift that is given to them. Right? And no, Ms. Jackson, I saw a conflict of interest. No, not because of a conflict of interest. It's just because the gift would fail. Any gift to them in particular would fail. But it seems here in this circumstance that the will not be valid. So we went through this already. Parties saw will, the formalities of a will. So based on the scenarios that we discussed before, we learned that a person must be of the age, they must be of the age of majority in order to make a will. So you must be 18 years old and you must comply with the formal requirements laid down by the Wills and Probate Act Chapter 903. The testator must have testamentary capacity, or they call it animus testendi. So it can't be that you have lost your mind in some way, shape, or form, and that you're making a will. It cannot be that you are unconscious. So therefore, in circumstances where persons are really much older, like for instance, in the first scenario that I spoke about, where the person that was 96 years old, what I would do as the attorney at law is to try to get a medical stating that the person had the capacity, meaning that they understand exactly what it is the instructions that they are giving, they understand the assets that they have, they understand who the beneficiaries are, they understand the consequences of it. So I go through a rigorous questioning, especially to my older clients, to ensure that no one is forcing their hands or bullying them into making certain dispositions. Okay? So the age of majority is 18 years. So according to the Act, this is section 42, it states that it must be in writing. So we discussed that earlier when it is the boy was making the voice note. That is not it will invalidate the will. So it must be in writing, it must be made by a person 18 years and over. It must be signed at the foot or end of the will by the testator or by some person in his presence. So in some circumstances, you will see the will is thumbprint. There's either thumbprint or somebody could sign on behalf on the request of the testator. Of course, there has to be a valid reason because then the attorney will say that the testator doesn't have use of his hands and he would have preferred to requested that. And there's evidence to show that the testator would have given the position, but that is very technical because then anybody could sign anything and say it's the testator gave them permission. It doesn't work like that. It has to be specifically stated by the attorney to prevent any fraudulent actions, right? And it must be made and acknowledged by the testator in his presence in front of 2 or more witnesses who would attest to the will in the same time. So at number 4, you see here, such witnesses must attest and subscribe to the will in the presence of the testator and each other. So P.S. a witness cannot attest to a will by a cross or mark or any other signature than his own handwriting. So once again, it leads us to consider who will be my witnesses for the will, who I could, these are things that you really take into consideration. Who will I appoint as an executor? Who is a trusted person that I could say, all right, I'm leaving this with you to do this for the benefit of everyone or all the beneficiaries and so on. Who will witness the will? Now, I always try to tell persons, get somebody much younger than you or not living a reckless lifestyle or something like that, because you want your witness to be alive when it comes to verifying your will. Because later on you will read that when applying for the grant, you need a document from one of the witnesses to confirm that they were indeed present and they saw that you signed the will in the presence of the other witness. So you want somebody who would be around longer than you, in essence. Right. Somebody asks, who can be a witness then? Anyone else? I would always try to say, for instance, you go to the attorney's office, probably the secretary could be a witness. In some instance, the attorney is a witness. I would say get somebody that that could be found, easily found, not MIA or living abroad or something of the sort that it's difficult to contact them. Right, I'm seeing another question. Let me just deal with a few of these before we move on. If the will says divide land equally and a grandchild was granted piece long before death, is that piece counted in the amount to be divided? It depends on what is done on the property. It depends on what is done on the property. If the property is subdivided and he or she would have severed the parcel of land and it no longer forms part of the gift, then. But in some circumstances, if it was already gifted, why would you then come and say in the will to subdivide it? So it means that there has to be some clear evidence that the testator wanted to benefit the person. So I suggest go to your legal representative and sit down and break down what the issue is, and they would be able to guide and advise you accordingly. What occurs if a will is found after the process has started or if process has been completed with asset distributed based on no will? Well, it depends on the fact that the will has been found much later. The only way that they could act is if there is still assets available. If the assets have been distributed, unfortunately, the court would have made the grant based on the information that they had available. And if there is no property left, say for instance, it's money and the person would have already spent it, it's hard to then come and punish and say, well, hand back the money. So each circumstance is kind of peculiar. It depends on whether there's instances of fraud or attempts to hide the will or so on. Ms. Bailey. Right. Right, so let's move on. I will get back to some questions after. What does it mean to have animus testendi or mental capacity? The testator must have the mental capacity to make the will. It means that he must know and approve of the contents of the will. There are some persons that sometimes they suffer from Alzheimer's or dementia, and so on, and they want to make a will. It's not that they are prevented from making a will. It's just that it has to be made on the advice of a medical person, probably a psychiatrist, who could confirm that they are fully aware and knowledgeable of what they're saying. Because persons, even though they are mentally, for instance, somebody who is mentally unwell, they have period of lucid intervals where they understand and they know. And if it's caught during that period of time, it will be valid. Of course, in circumstances like that, it's very easy for somebody to say, no, the person didn't make the will. They didn't understand what they were doing. They weren't correct in their mind. And of course, you have to bring evidence to combat that, to show that they did indeed understand, and it is their intention to benefit the persons that they would have stated. And been made of a genuine free choice of the testator. So it can't be that somebody's forcing your hand. So sometimes we have issues where children are literally there forcing the hands of their parents to leave whatever property to them, to do whatever. And that sometimes, of course, it's very, that's problematic. So I often, in my office at least, I pull them aside, I speak to them one-on-one just to understand and just get the circumstances correct. And you'll find most attorneys during the consultation period, especially with someone that is much older or so on, they will take the time to really get the details and the information needed to ensure that they are doing it on their own free will. Right? So in this closing of this part, I always recommend that when it is you're dealing or contemplating making a will or estate planning, please visit your legal representative for guidance. Any wrong action can invalidate the document. And it cannot be corrected if it is you're no longer living. So I've had instances where persons attempt to save costs. They attempt to save costs by doing it themselves or doing the research, or I even say, even in attending seminars like this, what it's meant to do is to really and truly open your eyes to things that you look for. But I always try to put in and say, go to a legal representative so that you could get the necessary guidance. It's very difficult to make a will, and I've seen persons do it so far. I've seen circumstances where persons, they decide to save costs one way or the other, and they make the will. They have passed on, and the will is invalid. Either because you think that, hey, I could secretly write up a document, lay out what I have, you haven't appointed an executor, you are the only person that signed it, or the witnesses are in a case as stated before, it becomes invalid. You cannot correct it. It cannot be corrected if you are no longer living. So therefore, make the sacrifice, get the advice so that you're able to get a sound, solid document that will not be challenged, especially in circumstances where persons are mentally, doesn't have the mental capacity and so on. For instance, I've had a scenario in my office, a real scenario in my office, where there were two wills. One was done approximately 2 to 3 years before the person had died, and one was done the day before the person had died. And it didn't make sense because the first one would have appointed they would have appointed a daughter to be the executor, and they would have laid out their beneficiaries and so on. You could see that it was thought about because it was in instances like it was in instances where he would have listed great nieces and so on. So you could tell that he had the capacity. And then the will that was done before, somehow it was done by a caretaker. The executor was all of a sudden the caretaker, and everything went to the caretaker. And in those circumstances, of course, it raises a red flag because one, it was done before the day before the person died. And we have witnesses that says that the person was completely out of it. They were completely out of it right before their death. So in instances like that, it becomes more contentious. So trying to save costs one way or the other, you know, you end up having to spend more in the back end because now it's a whole full-on court battle. And I always say this as well. If it is you intend to benefit, if you intend to benefit somebody that doesn't fall in your immediate line of family, I always recommend doing a will or inter vivos gift. Because should you not leave a will, the law dictates how your property is distributed. And it means that if it is you intended to benefit an aunt or a niece or a nephew somewhere along the line, most likely they will not receive a benefit if it is you do not have a will, a valid will. And I always remind persons you can change your will at any time before death. So if your circumstances have changed, you come into some money, sometimes people argue and say, I don't have any money, I don't have anything to leave. And after they died, they come into money. I always say at least leave a basic document because in some instances, I've seen where persons would have passed. They had nothing when they were alive. However, because they passed by way of accident or so on, the insurance then will get the money, they will pay out the money, and then you realize you accumulated some assets after your death. So these will have to be distributed in one way or the other. But I guess if you're not receiving the benefit from it, however that's what I get from some people. However they hang, they swing, let them figure it out. I have some questions here. Let me just go through. If you obtain a property while you are married, can you will the property to a child? Yes, you can, because the benefit of the will is that you're able to distribute your asset according to your wishes. Yes, so you can, unless of course, it might be matrimonial property or the wife or husband or somebody has some kind of interest in it, then that is where the challenge might be. But you are able to do it. You are able to gift it. Do all wills have to be probated? Absolutely. And this is what we'll deal with after when we go into what happens after you die. All wills have to be probated. You cannot, a lot of persons will come to my office with a document and say, I am the executor. I am the executor and they're waiving this will, but you don't have the authority until and unless you have the grant from the court. So yes, all wills must be probated in order to have any valid effect. How is the cost calculated? We will deal with that shortly. Yes, marriage and the other questions from Ms. Bailey is marriage invalidates a will. Do you have to make another will after marriage, dividing your assets between your siblings and your spouse? I would say yes. And of course, if it is you go by an attorney at law for the guidance and so on, they would be able to break it down and put whatever they have to put in the document to show that you made the document in contemplation of your marriage to the person. Who benefits in the property if no will is made? A husband or adult children? Great, Amanda. That is signals our opportunity to move along. Right? Second, so we'll move on. Okay, I'm seeing Miss Baines here before thing. Should all wills register in probate and who should register it? Well, it's easier when it is the person go to register it, but it could be registered by the attorney because you have to sign an affidavit and all these things in order to register it. So no, all wills does not have to be registered. I always do my wills when I do wills for clients. Sometimes I do it in duplicate and triplicate. where I keep one in my office just in case, there's a fire or something that causes it to, that causes the original that you have. So I do it in two originals or so that there's always one that you could turn back to. If a search is done and no will is found, then you can proceed along the lines as we're going to discuss coming to the end. So, since so many people have so many questions, what happens after a person dies? So, after the testator dies, what should be your course of action? Now, I've had instances where it could be for lack of knowledge that persons would have waited sometimes 30 years, 40 years, 2 generations, 3 generations pass. I had a document from 1911. And I'm like, nobody, as the time proceeded, no, the person died since 1911, I believe, yes. And nobody probated the will after. Nobody tried to get any documentation. You could imagine how many generations passed. So we probably had the great-great-granddaughter of the person that died. And we are now in a quandary. So I always try to get persons to understand that after somebody dies, you have a duty to act. Whether you believe that you are the beneficiary or one of the beneficiary or the person entitled to apply, I always advise persons, try and find out where you stand in the circumstance. So what happens after the person dies? So it depends on the circumstances. An application must be made in the probate registry for a grant of either a grant of probate, a grant of letters of administration, or a grant of probate with will annexed to deal with the person's asset. So the circumstances are, oh my gosh, excuse 1 second, yeah? Depending on the nature of the transaction, you will be advised by your attorney at law what would be the appropriate application to be made. Who can apply for a grant? So this is important business because sometimes we have aunties running up, uncles running up. They're ready to apply for the grant. They're ready to benefit and they're not entitled to apply or benefit. So for an application for a grant of probate, these are done in instances where the deceased person would have made a will. Where the deceased person make a will, the attorney would format a grant of probate. In all wills, there has to be a named executor in the document. So these grants are issued to executors expressly appointed by the deceased person in a will. So therefore, the name executor would come to the attorney. They would draft up the documents in accordance with the will. There are some instances where the executor, they would have either died. Let me see. Yeah. They would have either died prior to making the application. They renounce and say, I no longer want to make any application or have anything to do with this estate. It's too much bacchanal. I don't want to be involved. Say, for instance, the executor was fine, but then after the person died, they became disabled or they lack mental capacity to make the application. Or if they move outside of the country, if they're no longer in the country, they are unable to make the application. Or sometimes, in some instances, based on the examples, the court exercises discretion to pass over the executor. In that instance, the law would have dictated who could apply for the executor, either earlier, grant to be applied circumstance, the court will look at the law the law. An application, if you all have seen the third application will be a grant of letters of administration. And this is where the person died, leaving behind no will. So they have left no will at all, or the will is either invalid because for lack of formalities, for want of formalities, right? So in those instances, you make an application for letters of administration, a grant of letters of administration. So moving along, the first person entitled to apply for the grant is the executor or executors. You could have more than one. So in some instances where you believe that the executor that you choose might have a difficulty, you could apply an alternate executor, or you could apply co-executors to make the application. According to the law, Section 30 of the Wills and Probate Act, the first person entitled to apply for the grant of letters of administration is the spouse of the deceased person. In instances where there are no spouse, then next of kin, which usually falls in the order of children. All the children, if you have 10 children, all 10 are equally entitled to apply, not one above the other. So in such instances, the attorney might be able to tell the multiple children, here's what, let one person or two persons apply for the grant, and they would sign a renunciation, not renouncing their right to benefit, but renouncing their right to apply for the grant, because applying for the grant is a two-part stage. Then, if there are no children, if you have no children, you have no spouse, you have no children, the next person would be the parents of the deceased person. And of course, sometimes, now these days, persons are passing away very young, so they might still have parents existing. But if you are much older, most likely your parents would have gone before you. And as such, your siblings then becomes the persons entitled to apply. And the law still have the saying whole blood and half blood, meaning that whole blood meaning me and you share both the same mother and father, and half blood meaning that we share one parent together. So it goes in those orders. And of course, if there is no spouse or no next of kin, then your property will be deemed, your estate will be deemed bona vacantia, meaning that no beneficiary, and it will go to the state. Sometimes we want to benefit, and I stated it before, we want either we have a common law spouse, or we have a niece or something that we want to benefit. I hope in the going down on this the breakdown of the next of kin, you realize how far down niece and nephew are. Because even after the siblings, then it goes down to the half blood, and then it goes down to probably the niece and nephew. It breaks all the way down until there is absolutely no one left, and then it goes to the administrator general. So if there is somebody that you intend to, or you have estimated to be more reliable, whether your niece, a friend, a goddaughter, something along the line, in those circumstances, you must make a will. You must make a will appointing them executor, because then the law make the decision for you. Right. Who can benefit? 1 second, let me just see. I see a new question coming. Would a common law spouse suffice? Yes. There has to be an application made to the court prior to be deemed a cohabitant of the deceased person. So to be deemed a cohabitant of the deceased person, you must be in a relationship for 5 years. You made the application for at least 5 years. So of course, more is greater. So if it is you come with 3 years or 2 years, no, you're not entitled to apply to be a cohabitant. If you're there 5 years and you have a child or two, something along that line, you have evidence of relationship. Of course, you'll have the witness statements and everything that confirms that you are in a relationship. And once the court is satisfied, they will deem you a cohabitant for the purpose of applying for the grant. So in that instance, you will be, in essence, the spouse of the deceased. And of course, as we move along, we realize that that causes a lot of conflict. It causes a lot of conflict, especially when it comes to children and cohab in a cohabitant relationship. So that could be a challenge. So that is the instance of who could apply. The other thing is who can benefit. So I have another scenario here that I want to engage you all in. Right? So Jim is legally married to Stacy, but they have been separated for the last 10 years. Jim and Deborah were in a common law relationship for up to 7 years until his death. They have 2 children together. Jim leaves behind 4 children, a house on a hill, and 2 vehicles. Who is entitled to benefit from that's supposed to be Jim's estate? Let me get some questions. We getting some Deborahs. Any other? Stacy and the children. Both. Everybody, including the children. Wife. Stacy and Deborah. The legal wife and all the children from the marriage. What about the children outside of the marriage? Because remember, he has 2 outside of the marriage. Okay, so most people are saying the wife, Stacy, and the children. And the reality is that in the instance, according to who could benefit, Stacy could benefit, Deborah could benefit, and all 4 children will benefit. According to the law, well, Stacy is the wife, so therefore she's entitled to apply. On paper, she has the proof. She had the marriage certificate. She have all these things. And I guess in those circumstances is where it is you see somebody die, and even though him and Deborah were together for the last 7 years, Stacy might just jump in to take the body because you have the actual marriage certificate. And the reason why these things are challenged, because generally stating Stacy should not benefit, ethically speaking, because Stacy and him has been separated for 10 years. They have no relation, so she shouldn't benefit. However, because she have the legal documentation and paper, there is something to be said about that, right? So there is some weight to that. However, if I am Deborah's attorney, then I would make the application to be deemed a common law spouse, because as stated before, you have to be in a relationship for at least 5 years, and you have evidence of togetherness, whether pictures, children. She has 2 children. So therefore, she will also be entitled to benefit from the estate. So in those instances, you would find Deborah and Stacy splitting 50% of the estate among themselves, and the other 50% would be distributed among the children equally. That according to the law. Polygamy is not legal, so therefore it has to be under the provision of cohabitation, of the Cohabitation Act, right? So in essence, everybody is going to benefit in this instance. Of course, if Stacy doesn't claim anything, that's if Stacy is fighting it. If Stacy says, well, no, I've been separated for the last 10 years, I'm not interested, we're not together, Deborah and the 4 children would be sharing in the estate. Of course, Deborah receiving the bigger share. So that's another yes, that's another issue that is in contention all the time, because outside of benefiting, we find that persons aren't satisfied with the share, or they're not comfortable with the share that is given to the spouse or given to the children, in essence, because that causes a lot of conflict. Sometimes the children now believe that they want, they should benefit more than the spouse, or they should benefit more than the cohabitant. And sometimes if it is, you have a situation like this, and Deborah, say for instance, Jim had adult children with Stacy, then they would feel slighted, the fact that Deborah is now walking away with not only her share, but also that for her two children. So now you find a lot of conflict happening between the family because of the transaction. But once again, the law dictates how these property is distributed, because they assume that the spouse would want to make certain arrangements. It's not bigamy because they're not married. It's not bigamy because they're not married. Him and Deborah aren't married. However, the court has the ability to deem her cohabitant, because um this is a serious scenario, because I've heard it before in recent settings where there is an instance where there is a long separation, and the deceased person would have been with the person for the cohabitant for a very long time. And there is a huge conflict between the legal spouse and the cohabitant. And it kind of probably puts it into perspective that we need to start to tie up some loose ends, because it can cause some conflict. So we have a lot of loose ends. Whoever has spouse and outside woman here, there, and whatever, and man, not just outside women, but outside men as well. We need to tie up some loose ends, because they can become entitled to apply and disrupt the entire system, and cause some conflict. And we don't always want that. So according to the Administration of Estates Act, in the event that you fail to dispose of your assets in a will or through inter vivos gift while you are alive, the law dictates how your assets will be disposed of. So according to Section 24, it states that where an intestate, so remember before, the testator was the person making a will. If you don't make a will, or you don't have a will, you become intestate, you die intestate. So this is where we refer to them as intestate and testate. So where an intestate dies, leaving a surviving spouse, but no children, and issues children, his estate shall be distributed to or held on trust for the surviving spouse, absolutely. So if it is you have no children, it doesn't matter if you have your mom there, it doesn't matter if brother and sister there, or niece, and feel like they're entitled, the spouse or the cohabitant receives everything in your estate once they have qualified. Okay, so in some instance you find, but I around here helping him for so long. This woman now come 5 years now, and she come and she get everything. Yes, because she's deemed the cohabitant. She's entitled to the entire estate if there are no children. So sometimes it's some parents find it unfair, some siblings find it unfair, but the reality is he would have formulated his own circle. Let me hear from you all. Do you all think that is fair? The instance where the cohabitant receives all the entire property if there are no children. Let me see. I've seen some questions coming in, some answers coming in. Sorry. Yes, yes. Now, to be fair, we have a lot more cohabitation happening in Trinidad and Tobago. We know that there's a misconception that, people say, I want to get married because I don't want nobody to get 50%, and I don't want, we hear that all the time, and I laugh it off as an attorney at law, because you don't even have to be married to have access to the benefit. So yeah, so it is fair. So we get a unilateral. It is fair from the persons who responded. If anybody says no, I would like to know why. because I mean, I'm mindful that it has some children who would find that it's unfair that somebody just came in and they would benefit. So I could understand, I could see it in that perspective as well. So where the intestate dies, leaving children but no spouse, his estate shall be distributed per stripes among the issue. What this means is that where he dies with children alone, no spouse, the children are the one entitled to benefit. So for instance, in the example that we used earlier, where there are 10 children, all 10 of them will break up the estate equally and be entitled to it. So in this instance, I always tell persons, if it is you have a child that you feel like should benefit more or requires more attention, say for instance, they may be disabled in some way, unable to work, mentally incapacitated, something along the line, and you believe that they need more care, in those instances, you need to make a will, because you would be able to make and to prescribe the necessary provisions that you want to ensure that this person is taken care of for the rest of their life. Because in this instance, everybody, the child that neglected you, the child that taken care of you, everybody gets equal share in the estate. And I always say, if this is your intention, you don't have to make a will, because the estate will be distributed in accordance to whatever you're saying anyhow. So if it is you intend for sister to be taken care of, cousin, anybody, make a will, because you will encounter some issues with the law. Does who can the person there say who you're asking for, does he have any right to his assets? Who has any rights to his assets? Right. So while he or she's responding, well, she's responding, I would move on. So where an intestate dies, leaving a spouse and a child, the surviving spouse shall take one half of the estate, absolutely, and the other half shall be distributed or held on trust for the child. So once again, if there are children and spouse, the spouse is entitled to 50%. If there is a spouse and multiple children, same scenario as before, the spouse is entitled to 50% of it, and the children will distribute accordingly. Where the intestate dies, leaving a spouse and more than one children, the surviving spouse shall take one half of the estate absolutely, and the remaining one half shall be distributed to or held on trust for the children. So we already stated before that we find that it's fair, and fair is fair. But that is according to the law. If it is you want something different, if you want to leave 20% for say 50%, or say 80% for the children and 20% for the spouse, you need to do a will. Yeah, you need to do it, because it's contrary to what the law says. So you need to put it in place. If there is no will and there is a surviving spouse and children, so they have spouse and children, but one child is listed as a beneficiary on a bank account, what happens? Now, there's a difference between a beneficiary on a bank account and joint owner. If you're a joint owner, after the death, the child automatically becomes the owner of all the contents of the bank account. Now, the beneficiary on the bank account, the process will still have to be followed, where the spouse would have to apply, and then they would give whoever the named beneficiary is the amount in the bank account. So that is one scenario, right? So let's move on and see where we get, right? So, like I stated before, the application must be made through an attorney at law. So according to the non-contentious business rule, all application for grants shall be made through an attorney at law. You cannot take it upon yourself to save costs, saying that it will be, I would try and do it myself. I could get a template and do it up. No, it must be made through an attorney at law. I suppose the reason being is that the probate registry is packed. It's completely overhauled with applications. And they want the applications to go through without the constant errors and so on. The attorney at laws, they know the procedure, they know what is expected, they know the stuff, and it kind of somehow intends to move the process along very much faster. Now, I know this could be a challenge because you'll find a lot of the applications, somebody leave a will and nobody did anything because they also didn't leave the resources necessary to make the application. So an attorney at law charge to do a grant, um, they charge based on the value of the grant. Now, a multi-million-dollar grant, of course, will pay significantly more than somebody that has a small estate of $50,000. I know most attorneys, the base figure, they only, after they call in the estate, they would be able to assess and tell you, according to the law, what the estimated cost is. But they're generally a starting cost, a down payment to say of around 7,500 to start the process and the application. Um, it involves a lot of drafting and so on. So attorneys, I know some people will be like, oh my gosh, no, but it involves sending letters to the bank, sending this, you're calling in the estate, the whole process of calling in the estate, which is to figure out all the assets that the person owns, whether he owns a house, car, whatever, bank accounts, all these things. You send out, you gather the information, and you place it all on an inventory. You do searches in the probate registry, you do everything, you draft it. So this is where I outline the contents of the application, which is the application for the grant and affidavit of due execution. So sometimes they have the affidavit of an executor. You have to sometimes go and search for the death certificate, the birth certificate, the marriage certificate, everything. You must have the original will if you're making the grant of probate, an affidavit of due execution, that is from the witness. You must have that. So we're hoping that the witnesses are alive. The inventory will outline all the assets that the deceased person, the testator or the intestate owns, and they put it in one document and come up with a cost, the value of it, and from the value is where you will pay the cost. Certificate of search, you have to do a search in the probate registry. So all these things have to be done. You have to pay your will duty in Register General. There are some instances where administrative bond is required. And of course, if there are multiple children and so on, you have to draft the consent renunciation. So depending on the nature of it, there may be more documents that are required, but for the base application, these are what the attorneys really process and draft, right? To get the application done. So in light of that, well, I guess we're coming to an end. So let me get some questions and we could probably use the last half hour or so to respond to these questions and have any concerns that persons may have. We could go right ahead and discuss it at this point in time. So I'll give you all a few minutes to kind of put your questions in the chat.
Right. If you do have any questions, please paste it in the chat. So I'm seeing a question here. On average, how long does it take to probate a will?
Wonderful. So it takes approximately, according to them, 9 months to probate a will. However, that could yeah, that could exceed. I would always tell people gauge for twice as much, a year and a half thereabout, because like I said, there is a backlog. So it finds that your application sometimes take a longer time to process. But the period of time from start to finish should be approximately 9 months, according to them. So if it is you're looking for immediate, if there's some kind of, sometimes you have goods that are perishable, you might have to deal with that prior to, because to wait on the grant will mean that there'll be no property or assets at all to deal with. Mhm. Yeah. Oh, Simonique, are you okay. I would go through the questions, right? Um, so yes, my son father is married with children. Does he have any rights to his asset? Yes, he does. He's a child. He's a child of the person. So yes, he has right. If he dies, of course. If he leaves a will, then something else is said. What would be the procedure to apply for a deed of gift? Now, a deed of gift is not an application, a conveyance transaction. And I said you're referring to land or property or someone. So the person has to be alive to make that conveyance. It's a transfer of one person to the next. So therefore, it's not an application. You just have to make sure that the person has, they know what they want to give. They have ownership of the document, because there's a general rule: you can't give what it is you don't own. So therefore, if you don't legally own it, chances are you cannot legally transfer it. However, for a deed of gift, you get your documents, you'll have to probably get a valuation report, stamp duty, all these things have to be in consideration. And of course, it's done through an attorney who would advise accordingly as to all the documents they'll need. Probably need the original deed, the they will tell you when to get a valuator and all these things to make the application to stamp duty, pay the stamp duty, register it, and you get the deed of gift. Are they similar to those mentioned for a will? No, there is no application. It's like I said, it's a conveyance, and this is probate. So it's two different documents. Is there a way to find out if a family member did a will? Yes, there are ways. Now, if you do a search, the attorney at law, every time you go to them, they would advise you. But if the person would have died, you could do a search in the probate registry. You could do a search in their properties and papers if you're not able to do that. So I always recommend a search. Well, a search must be done. It will show up if they lodge any will or any applications or anything that is made at the probate registry. And if you can't find anything in their papers, their important bundle of documents, then most likely they wouldn't have made a will or not. Yeah. Are there alternatives to using a will as the main way to transfer assets? Of course, you could do it inter vivos, meaning you do it while you're alive. Now, there are ways so that you could do it while you're alive, meaning that you could do a conveyance, a physical a conveyance of the land, you transfer it over to them. You can hand it over in terms of the jewelry, in terms of vehicle and so on. You could go to the licensing and get it transferred over to their name. And that way you don't have to go through um you don't have to go through the process of probate, because it could take a long while. But what happens in those instances is that you pay a lot of the money at the front. So that is the issue persons have. They don't want to pay the fees. So you either decide if you're going to pay it at the front end or you're going to pay it at the back, which is when you do a will to make the application. But it takes a lot of upfront payment, because when you calculate stamp duty sometimes on transferring a land, it means that you have to do a lot. You have to pay a lot out of pocket. Can a stepchild make an application? Yes, a stepchild could make an application, providing that they are named as they are named as the executor, so they could make the application in those circumstances. Um, in other instances, a stepchild could be deemed a child of the family. So it all depends on, of course, they have to apply to the court to be deemed, just like the cohabitant has to make an application to the court, there's an application that has to be made to the court to be deemed a child of the family, meaning that the person would have considered you, in a sense, adopted you. Child, they will be deemed a child of the family. A trust could be made, a trust document. I saw somebody asked about it earlier. A trust document a trust is an alternative. However, the process in Trinidad and Tobago is a bit more sketchy, a bit more uncertain, as it's not commonly done. But a trust could be created what the put in place. You'll have to execute according. So it's a lot longer process. The reason why persons go and lead towards a will is because it's a lot easier to do and to apply. I'm coming to the chart. I'm just going through the question and answer segment here. The question and answer portal. How are debts like a mortgage supposed to be handled after death when a spouse and children still living in the house? So good question. So according to the law, debts are paid first. So in some instance, if it is you have a mortgage, persons are advised to, by the banks, of course, to have a life uh, uh, a life insurance policy attached to the bank. So what happens in those circumstances, you'll find that when the person dies, the insurance will pay off the mortgage, allowing the spouse and children to continue to live in the home without having to pay a mortgage. However, in instances where there are no life insurance policy and all these things, then of course the interest, even though they left all the will and all the beneficiaries and all these stuff, the property, the house, the interest will be to pay off debts first. So the bank will be coming for the remainder of their monies, or you could just enter into an arrangement where you, the spouse, continue to pay the mortgage. So in some unfortunate instances, the bank will sell the property and the spouse and children will be able to benefit from the equity built up on the sale.
Ms. Duke,
Amanda, I don't understand.
Okay, go ahead.
Yeah, sure. Mm-hmm. Go ahead.
If a spouse was an applicant while probating a will and the spouse dies, who can follow up on that application?
If the spouse was the applicant, the children. Yeah, you provide evidence that the spouse has passed, and the children will make an application as beneficiaries and of course the next person in line entitled to apply for the grant. Amanda, I don't understand, can a house be claimed on a minor's property? A minor's, I'm not understanding that, so you can probably retype that. So I'm going into the chat now. Sorry, Simonique, where you read that from the chat?
Yes, I did.
Okay, all right. So I will just continue from where you left off. So what happened if what happened if the beneficiary of a will dies before probate is finalized? Well, depending on who the beneficiary is, if the beneficiary has a family of their own or so on, it goes to her estate. Yeah, or his or her estate. So if the person would have passed and they say, for instance, is an adult child and they have a spouse and children, their portion goes to their estate. So once again, in this entire process, it depends on who dies first. if the beneficiary would have died prior to the testator dying, then their gift fails. It goes to the residue of the estate. They no longer have an interest. However, they die after, then the challenge, then it goes to their estate and whoever is the benefit from their estate. So what does the testator need to have in order to get a will done? Well, I always tell them, when you come to my office for the consultation, have in mind who you want to appoint as an executor. Sometimes they come first and they want to just have the information. So whatever we talk about today, we talk about it in a meeting. They want to have the information as to who they should appoint as executor. They need to know what assets they possess, because sometimes by the time you take in the office trying to say, okay, I have an account here, I have an account there, I will tell them, come prepared with the account information, all the information that you have and who you want to give it to. So you have to outline the beneficiary, outline the assets that you have, outline the who you want to be an executor. And once you come with those information, we could start with the drafting and move along as we go. And of course, I would advise, well, that is not possible. You probably shouldn't have that, according to what the law states. Yeah, but I do think it's a will is generally inexpensive. And when I say inexpensive, depending on how much assets you have and how long it could be, because I've had instances where I've drafted 5-6 pages of will. So that means multiple hours of work trying to put it together. So depends on it. A simple will could be very cost effective. If your bank accounts are in your name only, how can your spouse and children get access to the fund in it? Can you use a will or other document? Absolutely. So if you don't have a will, then the attorney, when they are making the application, they would call in your estate, meaning that they would write letters to the bank to let them know this person is entitled to apply, and we want to know whether Ronald have any accounts at RBC Bank. He has an account and he has this amount in it. Once they have the grant, they would then be able to access the funds in the account. If there is a will, of course, you could distribute accordingly. I want 20% of the proceeds to go to my daughter, 10% to my niece, this, that. You could outline that in your will. Which is more economical, for my mom to do a will or a deed of gift? I am my mom's only child. Well, in that instance, I would say both will cost the same thing. It depends on when you're Carla, that is. It depends on when you are ready to spend the money. So are you spending the money up front or are you spending the money in the back? So in your instance where you and your mom, you are your mom's only child, I don't know if she has a spouse or whatever, but that could be a consideration as well. But you are the only child. So in that instance, I would suggest a deed of gift if you all could afford it up front. And I would do a deed of gift in both you and your mom's name. That way, God forbid, if something happens to your mom, you automatically becomes the owner of it. You don't have to apply for a grant of probate. You don't have to do any such stuff. But you just be to pay the monies up front, inflation costs, the stamp duty, and of course valuation and so on. And you save yourself a lot of time with the property being automatically assigned to your name upon her death. Will Natalie, I'm not understanding. Will that was done and money was, how do you get an endorsement? Can you restate? I'm not understanding. What is a caveat and how is it applied? Wonderful question. So after you have applied for a grant, there is a period of time where persons, because what happened, the probate registry publishes it in the Gazette. Kelvin Bridgelal has applied for a grant in the estate of Tom Bridgelal, and it gives the person, whoever is challenging that, application to apply for a caveat. A caveat stops the grant. It tells the court, stop. This person is not entitled to apply. This person is not entitled to benefit. I don't know who gave Kelvin the permission to do it, but the life of a caveat is 6 months. So it means that when you file to stop, it means that you have within 6 months' time to make to file a claim in the court explaining why it is that person is not entitled to get the grant. If it is you just file a caveat, stop the process, and then you don't follow up with anything, it means that they will continue the process because the caveat is no longer in existence. The life of the caveat falls. So that's important to know. So a caveat is a document that, of course, is filed by an attorney on your behalf that stops the issuing of the grant temporarily. If someone dies and the surviving family members are unaware of the existence of a will, what would be the first step? If someone dies and there is no knowledge of a will, I would say that you get to an attorney and you get a search done. Once you get a search done and you're able to confirm, well, one, you will search in the important documents. If he or she doesn't keep it there, you then go to an attorney, have the attorney do a search. If the attorney do a search on probate registry and there is none there, then you all could proceed on the information that one does not exist. So therefore, an application would be made if it is, they have a house, they have a car, they have all these things. An application would be made based on a grant of letters of administration. Right? So, can you name a beneficiary for an estate under probate? I'm not sure what is meant by can you name a beneficiary, but yes, a beneficiary could be outlined in a will. And you would, of course, be able to entitled to apply for probate if it is the executor fails to do so. As Ms. Kelvin above spoke about caveat, I should probably also speak about citation. A citation, similar to a caveat, is something that forces the hand of the person entitled to apply to make the application for the grant. So, for instance, you are a beneficiary under a will and you say, oh my gosh, 2 years passed and the executor hasn't applied for anything. You talk to them and you say, apply for a grant, and they fail to do so and they refuse to do so. You file a citation forcing their hands. If they fail to act, then another person in the line of the order in which they could apply would then be able to apply. So the beneficiary will be able to apply for the grant and so on. But sometimes the excuse that the executor give, they don't have the money, they don't have the resources. So I always say, make sure that you leave a little change for the people to be able to apply for the grants, for the necessary grants so that they could execute accordingly. Well, I just spoke about trust, Keisha, and trust, a trust is where it is you leave somebody in charge of certain documents. So trust could be created. Like I stated, in Trinidad and Tobago, it's rarely done. However, it can be created. What you do in these instances is that you create a company, you have directors, all these things, a trust company in essence that is responsible for the distribution of assets upon your request. It's a lot more complex. So therefore, I always suggest that persons who are interested in a trust get an attorney who is familiar with the area so that they would be able to really navigate. Because it's a longer process, of course, than the will that is much simpler. So, yeah. A trust is not the same as a will. A trust is creating a trust is leaving somebody else in charge. For instance, if you have a minor child, they are unable to hold property and assets. So therefore, you say, I leave it to A for the benefit of B. So you have created a trust in that instance. That is the trust in terms of will. That is different to a trust company or a trust document that is outside of the scope of probate. Because what you do is you leave all your you give all your property over to the trust company who has the identity, and then they will distribute accordingly. So it doesn't really fall within the probate aspect. If a spouse were probating a will dies, who can follow up on the application, and as well if the letters of administration were filed and the applicant dies, who next to follow up? So a spouse, the spouse probating the will, I assume that the spouse is an executor, was named the executor. So in the instance where the executor die, one of the beneficiaries or the residuary beneficiary will be the person entitled to apply or to continue the application in essence. So a new application will be filed by the attorney. They would give the court the death certificate and all these things that while applying for the grant, the person subsequently dies, and as such, they would make the application under another grant, and they will get it to distribute. My uncle's will is in probate 5 years now. Well, that's a bit concerning because as much as they take very long, it never takes 5 years. So there either is some check with the attorney that did it to see whether or not they really made the application and when, because I've never heard a probate taking 5 years. They take very long, but you probably get 2 years for the most. So I don't know what is the challenge there. Are there any costs involved beside the costs in relation to property? If you're doing inter vivos, meaning a gifting while you're alive, the costs associated would just be the transfer cost. So property is the most expensive to transfer because you go through stamp duty and all these things. But outside of that, the remaining costs are quite nominal. If you have jewelry and you hand it over, it have absolutely no cost associated. If you have some pots in your kitchen and you say, I want to give Jenna this pot, you just hand it over to Jenna, absolutely no cost. But, licensing office to transfer a vehicle, you might incur a little cost there, depending on the age of the vehicle and so on. If you have money in unit trust and a credit union with my children name as beneficiary, is a will necessary? Well, for unit trust, no. Unit trust corporation, the name beneficiary, you said your children are beneficiary. I'm going to assume that your children are adult, meaning that they could act for themselves. They would be able to go to unit trust and collect it. For the credit union, I think there is a tab of up to $50,000. So if you have more than $50,000, the beneficiaries will not be able to collect all, but the 50,000 they will have. So, in those instances, I would say to kind of avoid the probate or will process, you could probably decide to take out and have it in cash and hand it over or something like that after you have gotten all the use out of it. Yeah. Okay. Okay, I think I've lost my way. Can you give a house? Can you give a deed of gift to more than one children? Yes, you can. Is there one remaining or surviving beneficiary? Sorry, where was I?
Go ahead.
Simonique,
yeah, you're correct. Go ahead.
Okay, all right, okay. Is there one remaining? If there are one remaining beneficiary and children from the dead beneficiaries, are these children entitled? Once again, it goes to who is or to when they died. Yeah, if they died prior to the person who is entitled to benefit, then they no longer forms part of the estate. However, they die after, then would be entitled, or whoever would be entitled to benefit. If a trust is applicable, see we have a few minutes left. So let me see if I could go through quickly. If a trust applicable or usable in Trinidad and Tobago as a way of transferring assets on debt, yes, a trust is applicable. It has to be done in a particular way. It has to be done very effectively to ensure that there is continuity after. Yeah. If you live common law with your partner, you live common law. Your partner died, you file for letters of administration. When finalized, your partner mother is the beneficiary. You have a child, they got nothing. Is that lawful? Um, no, it's not lawful. It sounds a little Patrice, I think you need to see an attorney because if it is you have one, if you're able to apply for the letters of administration, that means that you've gotten an order of the court deeming you the lawful spouse. And if there's a child, if you haven't made that application and there is a child involved, meaning that you apply on behalf of your child is the sole beneficiary, no one else should have it. So you should probably see an attorney for that. My brother died by accident. His wife of 3 years has separated for 25 years, no children. So he was married for 3 years. Well, in that instance, the court will require, I would think that his parents, Glenn, I think that his parents would be the next person entitled to apply if it is he has no children. Once they apply, the attorney will outline in the application that the wife, and of course you have your evidence to support that they would have been separated for 25 years now and all these things. But once again, this is the plug. Please close up these holes, loopholes that we have here. We need to start applying for divorces. We need to separate because it creates a lot of conflict and confusion, and sometimes you have to jump over a greater hoop. So the attorney, whoever is next in line to apply, would apply, either the mother or the siblings, but they would have to outline strong evidence to show that the wife and him has been separated and he had no intention for the benefit. And it will be up to the court for the court to allow it. Yeah, how can a trust could be used for planning estate because it, of course, directs, you have the ability in that document to direct how you want your property to be distributed for the benefit either for your kid or so on. You have your conditions. So just like the will and so on, you're able to outline your conditions and stipulations for any distribution to happen. You want to put things in place. Sometimes with the trust document, what happened? The trustees have an obligation to ensure that the property isn't wasted. So if it is, instead of giving your children outright the property, you really want to create something would continue to multiply. So they will invest. They will know when to distribute and say, okay, you're going to school, I'll pay your school fees, these things. You're able to really stipulate. So there could be a trust document separate and apart, and a trust could be created in a will. So there are two separate things that you really have to consider. So a trust could be created in the will, where you leave somebody, whether the mother, whoever, aunt, in charge to distribute accordingly. I'm leaving $100,000 for you. This is to pay for his university. This is to do whatever. This is to do whatever. And they would then know, distribute when it is he reaches milestone and pay for the school. But there's a lot of responsibility on the trustee because the trustee then has to ensure that they are taking full account of how much money they spend. Because if at a certain age, the child reach a certain age and they realize they didn't receive the benefit, there is nothing, they could then go to they could sue the trustee to receive the benefit for them to return the monies, and they will of course have to show, well, I use this amount a month to maintain the child, to pay for the school and so on. That is why he doesn't have any actual money remaining. Oh, I see we coming up on time, so let me not take too long. My uncle died. He has no will. His son is on the streets on drugs. Oh, Lord. His siblings and uncles are not interested in going through the administrative process. Is there anything as a niece? Yes. The attorney would go through the process of having everybody in order to renounce their right of entitlement. So everybody before you as the niece have to sign a renunciation to say they're not interested. Can you give a house via deed of gift to more than one children? Yes, I think I answered that. After what time period? Oh, gosh, God. I think I lost that question. Okay, yeah, so I think I lost that question. Let me see if I can go back. Natalie, what's your cost? It depends on the nature of the document. My probate was done and money was paid, the will was registered, and I thought I could have gone an endorsement, but with the search showing it is there. What you get back after you apply for probate is a grant. So the will no longer, you use the will as a guide to distribute, but the registered will is nothing. The grant is what gives you the authority. So that is what you get once you have gotten it. So you might have to reach out to get, some further information, but I'm not sure exactly. What kind of power of attorney get if the will? Okay, I'm glad somebody asked about a power of attorney. What kind of power of attorney get if the will, if there's a will and if there's no will, what can they get? Now, a power of attorney, persons don't get it confused. A power of attorney only operates when the person is alive. Once the person dies, you no longer have power of attorney. You understand? So you become a regular person. Yeah. So a power of attorney, whatever is the named, if there is a will, if there is something mentioned in the will, then they are able to benefit as a beneficiary. But the life of the power of attorney ends when the person dies. Okay. You need to go back to your attorney, Natalie, because you're supposed to get the grant in hand if everything was done already. Depends on how long it has been done. Does an estranged child, that is, one who has not lived with or claimed by the parent, but is biological child, also benefit from the will? If there's no will, yes, the estranged child could benefit as long as they could prove that they are indeed a child. So whether you claim the child or not, they get a paternity order to say that he is my father, and they would be entitled to benefit. Um, the law is that there must be a reasonable period. Yeah, sometimes you talk to the person directly. For the citation, the question is after what time period can a citation be filed? You talk to the person, you say, if you're entitled to apply, go ahead and apply. You talk to them, they say, I don't have no money. You all come to the conclusion, all right, we'll put up together so that we could make the application. If all that fails and all these things and the person just blatantly refuses, then you could file one probably within 6 months, a year, however long, if you really find that the time is going on. Can someone have a will in Trinidad and one in another country? Yes, the only one that will apply in Trinidad is the one done in Trinidad and Tobago. A will in another country, you will have to do another application to bring the will under the laws of Trinidad and Tobago. And of course, it must deal with assets in Trinidad and Tobago. Thank you. Okay. Yes, leave your contact information. Okay, I'll take a few more questions because we're already after 7. So, do you need to inform your beneficiaries that they are in your will? No. The executor will do so after. Sometimes when it is you inform them, you find yourself in some trouble because they're on you. But I always say try to inform the executor because the executor need to know what it is they need to do. If they aren't aware that there is a will, then of course they don't know that they have to apply. Yeah, it's different for when there is no will. Of course, the spouse ought to know that he or she is the person entitled. Yes, yes, Denise. Okay, so I think that brought us to the end. I think, yeah. Okay. Somebody say, are we getting a certificate of participation? Okay, so I'm seeing a question here from Casey Duncan. As the executor of a will, what legal steps must I follow to ensure fair and lawful conveyance of the property to minor children? As the executor of the will, you become a trustee in essence. you become a trustee, of course, you're not going to just give monies over to minor children and so on. You, depending on who the persons appoint as a trustee, you would transfer to them, of course, for the benefit. But as the executor, you have the responsibility to supervise all these things because you now become the administrator and trustee on behalf of all the beneficiaries. So when it comes to minor children, you really have to deal with them carefully because they cannot hold property according to the law. Some property in terms of land and stuff like that. So you need to put it in a particular way to ensure that they benefit. So it's your responsibility to get the attorney and the legal guidance. So, with that being said, that being the last question, are we getting a certificate of participation? That is for that's for PSCU to decide. However, it is my pleasure, as always, to bring you all the information. I commend PSCU for always taking the time to inform not only the members, but now members of the public, because it's so important that you all are aware of what your rights and responsibilities are. So thank you all so much for having me.
Okay, thank you, Miss Du, because I sure everyone would agree with me when I say that you have exceeded our expectation for this session. Bravo, bravo. Thank you very much. Right, as we come to the end of today's webinar on will and succession planning, I want to take a moment to thank Ms. Duke, especially for sharing light on her expertise of the importance of planning and protecting and securing your legacies, right? And to our audience, we appreciate your time and engagement as always. And before we wrap up, I want to encourage you to take that action, take that time, whether it means consulting a legal professional, such as Ms. Duke, or reviewing your existing will, or even just starting that conversation with your family. Please do it, right? And PSCU Credit Union is here to support you during your journey, providing financial guidance and solutions as well to align you for those long-term goals, okay? And again, remember to subscribe to our YouTube channel. If you have missed any part of today's discussion, the recording will be available on our YouTube channel, right? PSCU Credit Union. And remember to like us on Facebook, follow us on Instagram and LinkedIn. So stay tuned for our upcoming webinars. All right, have a good evening, everyone. And thank you very much for attending.